way back from a meeting when your phone buzzes. The notification says you have a new email from your head of PR to you and your CEO. So of course you open it right away and you read the following. You've seen the headlines. You know the Me Too movement has garnered a lot of attention. How will you respond when it touches your business?
What can you do today to minimize the risk of public allegations, and what steps can you take to prepare should the day come? Given the increase in allegations of sexual harassment and the impact public allegations can have on any business, you do not want to be caught scrambling to respond.
In the next 30 minutes, we're going to walk you through the legal and strategy considerations you need to be thinking about now, including preventative measures. First, we're going to talk a bit about how Me Too has changed the way companies respond to claims of sexual harassment.
Second, we are going to share 4 key lessons that will help you and your company investigate and resolve allegations of sexual harassment, including an overview of some recent changes in the law that are intended to promote workplace diversity and deter harassment. The 4 lessons we are going to cover are: 1, ensure that your procedure for handling complaints is robust and consistent, and proactively think through privilege concerns. 2, develop a culture where harassment is not tolerated. 3, stay on top of the latest changes in the law. 4, correct without overcorrecting. Prior to October 5th, 2017, when the first story regarding Harvey Weinstein broke in the New York Times, it was common for companies to quietly pay to settle sexual harassment complaints against high-powered executives and to try to limit the reputational damage through non-disclosure agreements. Agreements providing for confidential arbitration were also commonplace. Since the Weinstein story broke and the rise of the Me Too movement, however, public allegations, whether in the news or simply on social media, have become the norm. As of June 2018, Time magazine reported that Me Too has publicly implicated over 400 high-profile executives and employees in the previous 18 months. In today's environment, quiet settlements are riskier, becoming harder to justify, and may not be in the best interests of your company. Given the Me Too movement's focus on calling public attention to sexual harassment by naming those accused of misconduct, there has been a public backlash against non-disclosure and arbitration agreements, which makes them far less useful than they once were and can even be damaging. In addition, courts have held that settlement agreements cannot prevent employees from communicating with the EEOC and participating in EEOC enforcement actions. Indeed, administrative enforcement is on the rise. The EEOC has reported that in fiscal year 2018, it filed 41 lawsuits involving sexual harassment, a 50% increase from the year prior. New charges filed with the EEOC alleging sexual harassment jumped by more than 12% over 2017 to more than 7,500, the first increase in at least 8 years. Should the EEOC decide to file its own lawsuit, the allegations will of course become public, and any settlement must be publicly filed in court. While you will never be able to completely eliminate the risk of bad publicity, the focus of the Me Too movement is on ensuring that employers take allegations of sexual harassment seriously and that those who have engaged in misconduct are held accountable. The walkout of thousands of Google employees recently in response to reports that senior executives accused of sexual harassment were paid millions of dollars to quietly leave the company is just one of many examples. Ultimately, in the era of Me Too, the risk of backlash is greater where credible allegations of workplace harassment do not result in real consequences. At the same time, employers need to be careful not to overreact. So, how do you strike the right balance? And what legal considerations do you need to take into account?
As a starting point, let's review an employer's legal obligations with respect to harassment generally. These laws aren't new, they've been around for years. For many people, the first time they had ever heard of sexual harassment was in 1991, during the Clarence Thomas confirmation hearings, when Anita Hill accused Thomas, her supervisor at the EEOC, of sexual harassment. Although, as we know, Thomas was ultimately confirmed, Hill's testimony led to increased awareness of harassment in the workplace. After the hearings, the number of claims of sexual harassment filed with the EEOC more than doubled between 1991 and 1998, and women demanded better legal protection. Congress passed the Civil Rights Act of 1991, which added greater protections and remedies for victims of discrimination, including victims of sexual harassment. In 1998, the Supreme Court decided Burlington Industries versus Ellerth and Farragher versus City of Boca Raton. These cases and others state that employers have a duty to exercise reasonable care to prevent and correct promptly any sexually harassing behavior. In cases where no tangible employment action has been taken against the complainant, such as discharge, demotion, or reassignment, a defending employer may raise an affirmative defense to liability or damages subject to proof by a preponderance of the evidence. The defense comprises two necessary elements. One, that the employer exercised reasonable care to prevent and correct promptly any sexually harassing behavior, and two, that the plaintiff employee unreasonably failed to take advantage of any preventive or corrective opportunities provided by the employer or to avoid harm otherwise. This is commonly referred to as the Farragher-Ellerth defense. When it comes to establishing this defense, the Supreme Court has explained that while proof that an employer promulgated an anti-harassment policy with a complaint procedure is not necessary in every instance as a matter of law, whether a company had a stated policy suitable to the employment circumstances can be a part of the employer's defense that it acted reasonably. Moreover, a demonstration of an unreasonable failure to use any complaint procedure provided by the employer will normally suffice to satisfy the employer's burden under the second element of the defense. Where an employee did raise a complaint of sexual harassment, the reasonableness of the employer's response to such a complaint will be considered under the first element. In short, first and foremost, all employers need a robust complaint and investigation procedure for harassment complaints. This brings us to lesson number one. Ensure that your procedure for handling complaints is robust and consistent, and proactively think through privilege concerns. Your best defense to any civil suit or public allegation is that the company conducted a thorough investigation and responded appropriately based on the findings of that investigation. Therefore, you need to ensure that your company is clear and consistent in how harassment complaints will be handled. This requires you to establish a consistent process for handling complaints and communicate that process to employees. When creating your process or evaluating an existing process, at a minimum, you need to answer the following questions. How will employees raise complaints? The key consideration should be accessibility. Keep in mind that raising complaints of sexual harassment can be extremely difficult. Some employees may not be comfortable going directly to HR or to a manager. Who will handle complaints once raised? How will these individuals be trained, and how much discretion will they have? On the one hand, it may be difficult to come up with a set procedure that anticipates every possible scenario. On the other hand, too much discretion can lead to inconsistent approaches and results. How will the results be documented? You need to be able to keep track of outcomes, whether in individual personnel files, separate employee relations software, or otherwise. How will you ensure consistency and accountability? Consistency and accountability will be easier to track if you maintain centralized documentation rather than in individual personnel files. Consider implementing an audit or review process to ensure that those handling complaints are acting fairly and consistently in terms of both the thoroughness of their investigations and their conclusions and the outcomes. Importantly, no matter how good your process is for handling internal complaints, for complaints made against individuals in senior leadership, an independent investigation by a third party may be warranted. Any company will have difficulty defending its internal investigation process when the person investigated holds a key leadership position.
Whether you involve in-house or outside counsel, you need to be aware of how reliance on the investigation or disclosure of its findings may affect your ability to claim the attorney-client privilege. Be aware that if you want to rely on your investigation and any remedial measures taken as part of a defense to a civil suit against the company, you will likely waive privilege. Courts have repeatedly held that employers raising a Farragher-Ellerth defense waive privilege over their investigations because an assessment of the reasonableness of that investigation and any remedial measures taken is necessary to determine whether the elements of the defense have been satisfied. That said, at least some courts have held that if non-attorneys conduct the investigation, an employer can maintain privilege over communications between those investigators and counsel. Separate and apart from any reliance on your investigation and litigation, disclosure of the investigation's findings and any recommendations prior to any civil suit may also waive privilege. You may be tempted to share an investigation report that clears a key executive of wrongdoing. You may even be inclined to share a report that faults the accused in the interest of transparency. Although underlying facts are not privileged, counsel's reliance on certain facts informing their opinion is. It can therefore be difficult to draw a clear line between privileged communications and work product and non-privileged factual information. As a general guideline, the more information you disclose, the more likely you will waive privilege over the entire investigation. In other words, you cannot use the investigation as both a shield and a sword. A good example of how courts assess privilege waiver in these contexts is the decision in Doe 1 versus Baylor University. A few years ago, numerous allegations of sexual assault surfaced against Baylor students. In response to the allegations, Baylor retained outside counsel to conduct an investigation. At the conclusion of the investigation, outside counsel released its findings of fact and recommendations. In litigation, the plaintiffs argued that Baylor had waived the attorney-client privilege largely due to this disclosure. In response, Baylor argued that the report only disclosed underlying facts and not privileged communications. The court rejected Baylor's argument. In summary, the court explained, the findings of fact reveal that all findings were the result of outside counsel's investigation. A detailed, thorough, and rigorous investigation based on unfettered access to personnel and data. Contrary to Baylor's assertion, this connection between outside counsel and the 13 pages of findings reveals what facts Baylor provided to outside counsel, not just the underlying facts themselves. In other words, the findings of fact are a publication of evidence of the communications. Although Baylor had not raised the investigation as a defense, the court concluded that it is enough that the university selectively disclosed confidential attorney-client communications publicly to warrant a finding that it waived the attorney-client privilege with respect to those communications as a whole. In addition, even if you do not disclose the results of the investigation publicly, you also need to consider the risks of internal dissemination of any report. In the face of a challenge to the privilege of attorney-client communications, courts typically examine whether the communications were disseminated beyond those who need to know the information. Ultimately, while in-house counsel or outside counsel should certainly be involved in any investigation of sexual harassment, you need to keep the following in mind. Limit internal disclosure of the investigation findings to only those with a need to know. If you are considering public disclosure of an investigation's findings and recommendations, be aware of the risks and be thoughtful about what you choose to disclose. And at the end of the day, you are safest not to assume that investigation materials and communications will remain privileged and to proceed accordingly when communicating internally about the allegations and the investigation.
That takes us to lesson number 2. Develop a culture where harassment is not tolerated. It is, of course, critical to develop a work culture where sexual harassment is not tolerated. This often requires more than implementing an anti-harassment policy and mandatory training. It requires attention to company culture more broadly. For example, a culture based on rigid hierarchy and the consolidation of power may facilitate conditions for harassment. Psychological studies have found that power is associated with a reduced tendency to comprehend how other people see, think, and feel, which can impede empathy, a flaw that likely lowers the social and moral barriers to harassment. In addition, The majority of the high-profile cases of sexual harassment involve situations where the harasser had a disproportionate ability to affect a subordinate's career. The cases of Hollywood moguls harassing up-and-coming talent are prime examples of this. In addition, there have been rampant allegations of sexual harassment against venture capitalists by female entrepreneurs seeking investors. These scenarios not only make it difficult for victims to speak up, but also make it difficult for bystanders as they too fear negative repercussions. While you will not be able to completely eliminate a hierarchical structure at your organization, you can consider ways in which power can be diffused. For example, the absence of clear and consistent policies on things like promotions and internal transfers can facilitate opportunities for harassment to the extent the policy vacuum allows individual managers to wield too much power and discretion. By contrast, policies that reduce the influence of immediate supervisors by, for example, requiring others to be involved in decisions around promotions and transfers, limit opportunities for employees to abuse their power. Another way to diffuse power is to adopt a 360-degree review process. This is a review process through which feedback from an employee's subordinates, colleagues, and supervisor, as well as a self-evaluation by the employee themselves, is gathered. In contrast to traditional reviews, which are done only by an employee's immediate supervisor, 360-degree reviews allow employees to be assessed from multiple perspectives. This eliminates scenarios in which a single individual has the power to decide whether an employee gets a good or a bad review, which at many companies can also affect compensation. In addition, fostering a culture of accountability generally will discourage would-be harassers from crossing the line while also encouraging the targets of harassment to speak up sooner rather than later. This requires consistent enforcement of company policies unrelated to harassment. When employees see their coworkers and leaders being held accountable in other contexts, they are more likely to be willing to believe they will be held accountable for sexual harassment. In some circumstances, you may want to implement new policies in order to provide guidance on behavior expectations. For example, companies are increasingly revisiting their policies with respect to alcohol consumption at work and work functions. The most common scenario we see of workplace harassment involves drinking. We've all heard the story of the office holiday party in which a coworker drank too much and crossed a line. While you don't need to eliminate alcohol entirely from all company functions, it is worthwhile thinking through the circumstances in which alcohol is provided and to set guidelines around expectations. Importantly, even if the event is not an event that is formally company-sponsored, if the event involves work and a manager is present, this may be enough to hold the company responsible for what occurred.
Importantly, attention to diversity, particularly in senior leadership, also plays a role. Me Too has already morphed into discussions about the absence of senior women from companies and gaps in average earnings between male and female employees. Research has continually shown that companies with more women in management have fewer allegations of sexual harassment. In response to these discussions, the California legislature this year passed an amendment to the California Corporations Code that requires publicly traded firms in the state to place at least one woman on their boards of directors by the end of 2019 or face a penalty. The law requires boards with 5 or more members to add even more women by the end of 2021. Now, it is certainly questionable whether the law is constitutional, as it specifically creates a classification based on gender, and therefore raises questions of equal protection under both the US Constitution and the California Constitution. After signing the bill into law, Governor Brown even recognized that the law would be challenged and may not withstand scrutiny. However, regardless of whether it is enforceable, the law is clearly designed to send a message that more needs to be done to promote gender equality at the highest levels of corporate America, and is reflective of the sense that companies need to be pushed to do more on this issue. Even before the law was passed, there has been mounting pressure on companies to review and release their diversity statistics, including statistics on women in leadership roles, promotion rates between men and women, and the company-wide gender pay gap. While conducting such an audit can be extremely helpful in terms of identifying areas of concern or in need of improvement, sharing the information is not without risk. Some companies have made the decision to be transparent despite underwhelming diversity statistics in order to convey that they recognize the issue, set a benchmark for where they are currently at, and publicly commit to improvements. While the initial disclosure of poor diversity statistics may invite criticism, disclosing the results of an initial audit can allow the company in later years to publicize its progress as measured against the results of its first audit. Any decision to publicly disclose diversity statistics should weigh the pros and cons for the particular organization. To the extent information is released, be sure to have a communication strategy in place to present the information and respond to employee questions and concerns. For example, be careful about how you describe the statistics and the results. You do not want to be accused of mischaracterizing the data, such as by focusing on statistics that are good for the company to the exclusion of statistics that are less favorable. You also need to be aware that once you disclose that you have looked at this data and have the data readily accessible, any current or former employee asserting a claim of discrimination will be aware of this data and will likely seek it in discovery. While these reviews may be done by counsel under cover of privilege, any disclosure of the results may limit your ability to rely on the privilege.
Next, lesson 3. Stay on top of the latest changes in the law. Be cognizant of the fact that the laws in this area are changing and stay on top of all of those developments. As of January 1, 2018, no deduction is allowed for any settlement or payment related to sexual harassment or sexual abuse if the settlement or payment is subject to a non-disclosure agreement. No deduction is allowed for attorney's fees related to a confidential sexual harassment settlement or payment. In addition, there have been a flurry of legislative changes at the state level. California passed a law effective January 1, 2019 that will void any settlement agreement that prevents the disclosure of factual information related to a claim filed in a civil action or a complaint filed in an administrative action regarding sexual assault or sexual harassment. In other words, settlement agreements cannot prevent plaintiffs from discussing their allegations and other factual information related to their claims. The law does, however, allow the parties to agree to keep the amount of the settlement confidential. Washington has passed a similar law, voiding non-disclosure agreements to the extent they would prohibit an individual from providing evidence in a civil action regarding past instances of sexual harassment or sexual assault by a party to the action. New York and Massachusetts now require employers to have written sexual harassment prevention policies, including a procedure for making internal complaints. A number of other states have passed similar laws directed at countering sexual harassment.
Another target for legislative reform is pre-dispute arbitration agreements. At least one bill has been drafted at the federal level that would make pre-dispute agreements that require arbitration of a sex discrimination dispute invalid and unenforceable. While the prospect of passing such legislation in the near term is slim, you should expect efforts to restrict pre-dispute arbitration agreements of sexual harassment claims to continue for years to come. Some companies have even preemptively revised their arbitration agreements to exclude claims of sexual harassment or sexual assault. These changes to mandatory arbitration policies signal a corporate culture in which the company understands that requiring arbitration of sexual harassment claims may dissuade victims from coming forward, and also signals a corporate culture that values accountability, even where the accountability comes from painful public disclosures. These types of legislative changes are likely to continue. It is therefore critical that you stay up to date on the legislative changes in any state where your company has employees. This gets us to lesson number 4, correct without overcorrecting. Acknowledge that our culture is changing, but resist the temptation to overreact. It is understandably unnerving for many to see the numbers of those toppled by accusations grow. The recent summary dismissals of high-powered executives and celebrities have triggered worries that any person might be accused and ruined by false allegations, or that their past behavior could come back to haunt them as a career wrecker. In response to this fear, a number of studies show that men are becoming more hesitant to interact with, and mentor female colleagues. For example, respondents to a Source Media survey on attitudes towards sexual harassment in the workplace post-Me Too voiced concern that women would be excluded from work situations in order for men to protect themselves. One senior leader in the banking industry reported that several male colleagues had told her they were reconsidering mentoring women. A Pew Research Center survey asked respondents whether they thought that the recent focus on sexual harassment had made it harder for men to know how to interact with women in the workplace. 51% of all adults questioned said yes. As another example, Lean In partnered with SurveyMonkey to look into the possible negative effects of the Me Too movement for women's advancement. Nearly half of male managers they surveyed reported being uncomfortable participating in a common work activity with a woman, such as mentoring, working alone, or socializing together. Senior men were 3.5 times more likely to hesitate to have a work dinner with a junior-level woman than with a junior-level man, and 5 times more likely to hesitate to travel for work with a junior-level woman. Almost 30% of male managers are uncomfortable working alone with a woman, more than twice as many as before. While fear is understandable, permitting men to be so protective that they refuse to engage with women so that women are excluded from opportunities will only lead to other problems down the line. Allowing an environment to develop in which men fear establishing mentoring relationships with junior women will likely limit women's advancement opportunities and could lead to charges of discrimination by women who feel excluded. The reality is that men play a critical role in fighting harassment in the workplace. Rather than allowing this fear to persist, employers should provide guidance and resources for men to do so.
A fantastic way to do this is providing bystander training. As the New York Times recently described it, bystander training equips everyone in the workplace to stop harassment, instead of offering people 2 roles no one wants, harasser or victim. Bystander training should focus on providing employees with choices of what to do as a bystander, such as interrupting a situation in which a coworker is being harassed, talking to the harasser later to convey how they came across during the situation, talking to the victim later to acknowledge what occurred. Interestingly, studies have shown that the training will be more effective if men are involved in the training. For example, one study found a backlash against training when it was done by a woman, but not when it was done by a man. Even if you cannot have a man conduct the training, having a male senior executive speak to the importance of bystander intervention could have a similar effect. Regardless of who conducts the training, bystander training can provide a launching pad for discussions about respectful behaviors everyone agrees on. In addition to bystander training, communicating to all employees that investigations in response to any complaint will be fair and consistent reinforces the sense that all employees will be treated fairly and equally, whether they are reporting harassment or being accused of harassment.
So, turning back to our original email, how will you respond? Can you say that you have a policy and consistent process in place for making and investigating complaints? Can you easily search to see if any complaints have been made against your key executives? If so, do you also have access to the results of the investigations? If you cannot locate any specific complaints, how confident do you feel that your company has fostered a culture in which harassment will not be tolerated? Do certain managers wield disproportionate power? Are you aware of concerning comments in employee engagement surveys or otherwise? Are you up to speed on the latest laws of the relevant jurisdiction? Do you have a plan with respect to publicizing any report or investigation?
Ultimately, how you respond to this Me Too moment will require balancing multiple concerns, and we have only been able to touch on some of them in this training. As lawmakers respond to increasing allegations of sexual harassment and as the public mood shifts, decision-making around investigating and resolving complaints and identifying appropriate preventative measures is sure to become more complicated. For example, from a preventative perspective, if you audit your diversity statistics and identify a disparity, either in hiring, promotions, or pay, what can you do about it? If you decide to focus on recruiting more women, how should you go about it without raising concerns of gender discrimination?
In addition, in what scenarios are you under an obligation to report allegations of sexual harassment to your board of directors? And once you do, what is the scope of the board's responsibility? A related concern is how to keep investigations confidential, particularly investigations of key executives while they are ongoing and before any conclusions have been reached. These are just some of the questions you may face as you navigate through this cultural shift. Thank you for watching.
Thanks for watching Lawdition. Continue watching programs that will challenge your thinking, while getting to know the best lawyers in every field as they share their insights, and all while satisfying your CLE requirements. When lawyers audition for new clients, everyone wins.